Chair. It's great to be here with you. You will always be Madam Chair to me.
Thank you, Mr. Chairman.
You served for 18 years on the commission. You had concluded a term, but you were still serving and still chair of the commission because the statute says you continue to serve until your successor is qualified, meaning sworn in. And yet you're here with no successor. What happened on the way?
Well, I got a little email from the president, and he said, "You're out, nobody else is in."
So the FEC is an independent commission. Presidents nominate commissioners. The Senate has to confirm them. Does it say anything in the law about presidents firing commissioners?
It does not, and there's some court opinion that says that there's an implied requirement that people not get fired except for a cause. There was no cause given. And it's important that people be replaced rather than simply fired, because what has happened since then is another commissioner resigned, and as a result, there is no quorum at the FEC. So they can't really do any of the important work that they're supposed to be doing to make sure that the American people are informed about where the money's coming from and where it's going, and to engage in enforcement actions and rulemakings to clarify the law and to make sure that it is enforced.
So president, under your statute, has no power to fire you. You get an email saying, "Thank you for your service, you're out." What happened next? Did the commission object? Was there any sort of process? How does this work when you're Senate confirmed and you get an email that appears not to bear the authority of law?
Well, that email did not just go to me. It went to senior leadership at the agency. I think that was done on purpose to intimidate folks, to make them, to deliver a subtle message, or maybe not so subtle, that they had to make sure that they removed me, otherwise there could be further consequences. And I didn't really want to take anybody else down with me, but I was told that I had a very limited window to get my stuff out before they would terminate my access to the building, take me off the website, and cut me off from my email. And they did that.
So the bottom line is the independent commission did not fight this in any way. Did you consider fighting it in the courts, and what were your thoughts on that?
That was my first instinct, was to sue over this, but my firing was part of a larger pattern that is going on. There is a systematic effort underway to silence opposition voices, to silence independent voices. They're going after independent agencies. They're going after independent voices in academia, in the media, throughout our society, in places where I think a lot of people thought that they were safe and had, I don't know, First Amendment rights. So I think we have to look at this in the bigger picture. This is not just about me. There are a number of people suing who, based on the fact that they are still within their terms, probably have a stronger argument. And I want this to go forward with the strongest possible arguments. So I decided to take a back seat on the litigation in order for it to go forward with the strongest chance of success. And I don't know, given the Supreme Court, whether it's going to have a strong chance at all, but I wanted it to have the strongest chance. And I also wanted not to give in to this effort to silence people. So by leaving the agency and not leaving myself in this no man's land, no person's land, it gives me more opportunities to work with advocacy groups and to try and get the word out about what's going on in our democracy right now.
I think it's important to note that on the basis of current law, what happened to you is clearly illegal. Yes. The president, according to the Supreme Court, did not have the power to fire you because you were a commissioner of an independent commission. And the court, in a decision going all the way back to Franklin Roosevelt, said that presidents can't fire commissioners of multi-headed agencies just because they disagree with them. Roosevelt had said, "I don't think we see eye to eye," and the court said, "That's irrelevant." Surely the Trump people didn't see eye to eye with you. You've been a voice on the commission for enforcing the law and for disclosure and for limits on contributions and preventing coordination. So you were an obvious target. But I think it's important to note that what's happened here is the administration is counting on the Supreme Court when this case gets there. And as you said, it won't be your case, it'll be one of the other independent commission cases. They're counting on the court changing the law, going back and reversing its precedents and saying, oh no, we were wrong. Actually, the president can fire essentially anyone they want if they're not in Congress or the judicial branches. So for the moment, I'm still going to call you Madam Chair, even if your colleagues have, as I understand it, the remaining ones have elected someone else in your stead.
That is correct, and I appreciate you, Trevor. I agree with you that it was illegal, but as I said, I think there's a better role for me to play than sitting in the background and waiting for a lawsuit to go through the courts.
Now, after you left the commission, the president issued an executive order that purported to say, well, it did say, that all independent agencies, including the Federal Election Commission, which was specifically named in it, have to clear any regulations, policy changes with the White House, with the Office of Management and Budget, and they have to clear any court cases, arguments in court cases with the Trump administration Department of Justice. Now, my understanding is that neither of those have been done before. Why is it important that the commission not follow that executive order, and what power does the president have to issue such an order?
Well, I don't think he does have that power. It's particularly poignant in the case of the FEC, which was designed in the wake of Watergate to be an independent agency, a bipartisan agency. And I don't think Congress would have set it up that way, would have established a Federal Election Commission if they did not know that all decisions would be made on a bipartisan basis. So there's been a lawsuit over this, as you know. The Democratic Party committees have sued, and one of the things that I was able to do in my private capacity was to file an amicus brief, a friend of the court brief, arguing in favor of the independence of the FEC in particular, an argument that was not made, as I anticipated, by the agency itself.
So that was one executive order, and the other one came later, and was a Trump executive order talking about elections and purporting to assume a role in ordering certain results and procedures in federal elections. Were you surprised by that?
Well, I was, because the Constitution doesn't give the president any role in the time, place, and manner of elections. That is granted under the Constitution to the states in the first instance, with some authority also being given to Congress. But you know all about that, Trevor, because your organization has sued over that executive order. So please, you tell me about that one, because I think you are better informed than I am.
Well, we did sue. In addition to being a former chair, I'm the president of Campaign Legal Center, a nonpartisan nonprofit in Washington that fights for democracy. Thank you all. And nowadays we are fighting hard for the rule of law, particularly in the area of elections. So this executive order by the president said, it ordered the Election Assistance Commission, another independent agency, to change the federal voter registration form and to require physical proof of citizenship, i.e. a birth certificate or a passport or something, in order for people to be able to register and vote. That is not the current law. Current law is very clear that people who want to register have to certify that they are citizens. Under threat of perjury, they certify that they're a citizen, and then they can vote. Donald Trump and Republican lawmakers in a variety of states, but now in the House of Representatives, are trying to change that and pass something called the SAVE Act, which would require physical proof of citizenship. It's a huge barrier to voting because you, A, can't do it online or by mail anymore. You have to present it in person. And B, what you're presenting is a document that I'll bet most people in the room don't have, which is their original birth certificate or a certified copy. I've been trying to remember where my copy is. I'm not sure.
I know where mine is.
And the big problem for an estimated 70 million Americans is that if you are a woman who has changed their name along the way, say you got married or you got married and divorced, your original birth certificate won't provide the proof you need. So then you're going to have to bring in court documents to show name changes. It's a real barrier to smooth registration in a world where most countries automatically register people and you don't have to jump through that hoop. So the order by Trump said the EAC has to do this thing, even though they're an independent agency. And then it said that you had to, states had to get rid of all their current voting machines and replace them with a new machine with a different form of hand counting. Just by the way, the new machine doesn't exist yet and hasn't been certified, and they're to do all that before the next election, a recipe for chaos. And then there was a provision of it that talked about states not being able to accept ballots, votes, that are received after Election Day, even though they have been cast legitimately before and the postmark said they were cast before. And about half the states currently allow those votes to come in and count them as long as they're pre-election day votes. So those were the three pieces of the executive order. And Campaign Legal Center, I think that came out on a Thursday. We were in court Monday morning on it and drew a judge in the district. And we asked for a preliminary injunction on parts of that because we said the harm would be immediate in terms of the voter registration form. And the judge agreed with us. That was the very good news. Yes, I think that's it is worth applause. It's Judge Kolar-Catelli, and the two pieces of good news are, one, that she gave us a preliminary injunction ordering the administration not to pursue this and ordering the Election Assistance Commission not to change the form. The second piece of good news is she wrote a masterful opinion laying out the Constitution, the views of the framers, history since then, to make the point that Ellen just made, that the Constitution has zero role for the president in federal elections. It says the states shall determine election procedures unless Congress steps in and makes other arrangements. But those are the two entities that run elections. And the reason we dove in so quickly is that we believe this presidential executive order is only the first attempt by this president to interfere in federal elections. And of course, we have the midterms coming up. And I think there's a very legitimate worry that this executive order only begins his attempt to decide how those elections are going to be run, to challenge them if he doesn't like the results. And since the midterms will be the first time for the whole country to express their opinions on how things are going and perhaps change Congress, it is crucial that the president not be allowed a role in how those elections are run or in the results. So we are in that battle, and the first step was fighting this executive order.
And as you know, Trevor, this was an initial step, but there are other steps that the administration has taken to undermine the nation's ability to fight off foreign influence. They've disabled various subgroups within the Department of Homeland Security and the Justice Department that used to particularly go after cyber attacks and potential cyber attacks and potential foreign influence in our elections. And we're apparently not really doing that anymore. So I think there's a lot to be concerned about.
There's that, and then there are several states that, despite the clear current case law, saying you don't need to provide physical evidence to register in federal elections. There are several states that are saying, yes, you do in our state. And so those cases will end up in the Supreme Court, assuming that Congress doesn't pass the SAVE Act. That act has passed the House. It's currently before the Senate. It can be filibustered. And my belief is that the Democrats will be able to prevent it passing the Senate, but that's an important issue to keep an eye on.
And it's really important to understand because they always put it forward as if, well, of course we only want citizens to be voting, and so this should be a really innocuous change. But the practical effect is to require people to produce documents that most people just don't have and don't have access to, and it will end up disenfranchising millions of people.
So let me turn back to your time as a commissioner and the recent election. An unbelievable amount of money was spent, a historic $16 billion, I think is the estimate, $1.8 billion recently estimated as dark money. But an aspect of that you were in the middle of is that Elon Musk, one individual, the wealthiest person in the world, spent $300 million plus whatever the value is of owning Twitter and tweeting out on X all the time. But $300 million actually in cash reported that he spent on behalf of the Trump campaign, much of it spent in the key states of Pennsylvania and Wisconsin and Michigan, and spent in close coordination with the Trump campaign, meaning they actually had meetings and talked about what the campaign's needs were and where Musk was going to spend his money, which enabled the campaign not to. And I know, that the law says you cannot make independent expenditures in coordination with campaigns. They're not independent, they're coordinated, and they're strictly limited. So how is it that Musk was able to spend the $300 million basically as a wing of the Trump campaign and yet claim it's unlimited independent expenditures?
Well, that's because of some very bad decisions that came out of Federal Election Commission, decisions that I dissented from, but they nevertheless had the requisite 4 votes that interpreted words that you think you understand, right? Like public communication. You think you know what that means. Those are pretty easy to understand words, and yet the FEC has issued rulings that have defined that to exclude mass text messaging, flyers that you hand out in the course of doing get out the vote work at the grassroots level. These are communications, and yet the FEC has walled them off from the kind of communications that would be subject to our coordination rules. Now, why does that matter? Because the Supreme Court has actually upheld contribution limits to candidates, and those contribution limits are meaningless if somebody can coordinate directly with the campaign and spend hundreds of millions of dollars to benefit the campaign. That just blows through all the contribution limits. And it's important to note that the FEC was created 50 years ago, just past its 50th birthday, with very little fanfare. I don't think the commission did anything to mark the event. It was organized in the wake of the Watergate scandal, which involved about $1 million. With inflation, that would be maybe $6 to $7 million today. But the country was scandalized, riveted to their television sets to watch these hearings about this $1 million scandal. In this past election, there were 6 individual donors who each gave more than 100 times that amount, $100 million, culminating with Elon Musk and his almost $300 million. Now, the Supreme Court, in a series of decisions, and I know you've all heard of Citizens United, that was one of the worst, has said, ingratiation and access is not corruption. And we cannot limit the amount of money that people want to spend to try and influence the outcome of an election. Well, look at the kind of ingratiation and access that Elon Musk bought for himself. He was invited into the government with his chainsaw to decimate federal agencies, agencies that were investigating his companies, and at the same time, putting himself in a position to benefit even further from more government spending. So the very wealthy will get benefits in terms of tax breaks and government contracts to these very already wealthy companies at the same time that they are looking to slash benefits to the poorest and most needy members of our society.
And the heart of all that is that the Supreme Court has said that you can limit spending by wealthy individuals and by corporations if it's going to be coordinated with candidates, because the court has said you can prevent corruption, and that includes giving a lot of money to a candidate and coordinating with a candidate, the court has said, is the same thing. So what you have is the Federal Election Commission, your agency, going out there and carving this huge Musk loophole in the law. I will say that the loophole was requested on behalf of a Democratic candidate, but in my career, what I've always seen is the Democrats ask for something to help their person, and then the Republicans drive a Mack truck through it, or in this case, I guess, a Tesla truck through it.
Or I don't know, maybe it's a 747.
So let me ask you one final question. Oh, I guess it will be. One final question. We've talked about the FEC creating this huge loophole. That's something they did, meaning a Democrat voted for it along with 3 Republicans. But then there are things they haven't done. And when I looked at the commission's testimony before Congress, there were 64 complaints filed over the last years against Donald Trump, the candidate, or his committees. The FEC staff reviewed them, and half of them, they said, showed violations of law. There should be a reason to believe investigation by the FEC, and then conceivably financial penalties or going to court. How many of those 33 did the commission then go ahead and investigate?
0. Absolutely 0. The president has a remarkable track record at the FEC of not of A, drawing a lot of complaints, but B, having those complaints go absolutely nowhere. And this is something that I wrote about when I was on the commission, and is probably one of the reasons I had a target on my back.
So that's because the commission is an even number, 3 Republicans, 3 Democrats, and it takes 4 votes to do anything. So last question for you.
And there's never been
How
a
do we
Republican
how
vote.
do we fix this problem? Because the commission now doesn't have a quorum. There will be people nominated, presumably of both parties. But what should we ask them to be doing to make the commission more effective than it has been?
Well, I think, first of all, there's no guarantee that new commissioners will be nominated. We just don't know. The last time the commission didn't have a quorum was in 2020, another big election year, and it went most of the year without this same president, nominating new commissioners. So in the year that broke all previous fundraising records, there was no cop on the beat at the FEC. Eventually, they did nominate the president did nominate new commissioners, and when he does, if he does, I think we need to look very carefully at who gets nominated, because it matters a lot. It matters a lot who is sitting on the FEC and who gets to make these decisions, because as we have seen, the FEC is perfectly capable of not enforcing the law or adopting any meaningful regulations if it is so inclined to do so. So we just need people who believe in the law to be serving in the government.
So in the meantime, in the absence of an effective commission, you need to keep writing amici briefs and op-eds and telling people what's going on, and we will keep fighting in court to ensure the rule of law and fair 2026 elections.
And everyone needs to keep paying attention and speaking out on these issues, and that's why it's so important that you all are here.
Thank you all. Thank you. Thank you, Ellen.
Thank you, Trevor.